We are convened this morning for purposes of imposing sentence in cases involving People versus Andrew Mason and People versus Hilery Maison. They are present in court represented by their attorneys, Mr. Boucher and Mr. Lupper. We also have the prosecutor present on our Stroll. The first order of business is, of course, to ensure that the pre-sentence investigations that have been now completed in the report is provided to the court has been reviewed by all parties. If there are any corrections to that report or any challenges to guidelines to the applicable offenses, then we have an opportunity to address those issues. Do you have any issues with regard to the content of the report itself?
Judge, good morning. Fred Lovely, here on behalf of Andrew Mason. As it relates to the content of the report, I don't have any objections to the accuracy. We do have, and I know Mr. Boucher also has some challenges to the scoring guidelines, which were just presented.
And Judge, likewise, Michael Boucher, on behalf of the defendant, Hilery Mason, we have no objections to the body of the report and the facts that are set out in the body of the report in terms of the recitation of the agent's description of the offense, which essentially comes from the police report and the transcripts and things related to trial, but do have challenges as to the sentencing guidelines.
What are those challenges be?
Judge, first of all,
let me just say the sentencing guidelines do not apply to all of these offenses. They certainly don't apply to those offenses such as the felony murder charge, which requires mandatory life in prison. So we're discussing the applicability of these guidelines to the other offenses, correct?
correct, Judge. We were provided the sentencing information report as the guidelines as it relate to the offense of torture. Those are the ones that I'm going to be addressing. Judge, and I don't know, because I think Mr. Boucher and I have similar arguments on these. I don't know if you want to take those together at the same time or do them separately.
If there are similar objections, you might just vote together.
Okay. Judge, the first one that I have relates to the scoring on OV7 on that particular offense variable for aggravated physical abuse. My client was scored 50 points. The definition there is that to score 50 points, the victim was treated with sadism, torture, excessive brutality, or similarly egregious conduct designed to substantially increase the fear and anxiety a victim suffered during an offense. Obviously, we had a conviction for the crime of torture in this thing, but there are different variables, different ways that a jury could have reached that determination. If this was more of a situation where there was a neglect or a reckless act on behalf of my client, I don't believe that 50 points should be scored under this variable.
And Judge, likewise, I would share the observations of Mr. Lefley. Certainly, we both understand that our clients were convicted of 2 counts of torture, but in light of all of the facts in this case and how the evidence was received by the jury, we believe that it is certainly possible and it would be reasonable to score 0 points with regard to this variable.
Response?
Your Honor, obviously preponderance of the evidence is the standard in scoring the variables, and I think that to characterize it as Mr. Lefley did as a reckless or neglectful type of act is certainly contrary to the facts and evidence that this court heard, as well as the jury's verdict. The verdict did in fact find intentional, purposeful conduct on the part of the defendants, and certainly the facts which demonstrate that these children were purposefully malnourished to the degree that they suffered the harm that they suffered would support a finding that they had endured excessive brutality or conduct substantially designed to increase the fear and anxiety a victim suffered. Sadism is designed as conduct that subjects a victim to extreme or prolonged pain or humiliation and is inflicted to produce suffering or for the offender's gratification. And certainly, and particularly as it relates to Mackenzie and the condition that she was found in terms of not only what caused her death, but her genital area and the other factors that I know this court heard, the bruising, there's certainly ample support to find a preponderance that excessive brutality existed in this case.
The testimony from the medical examiner attested to the brutality of these children who were subjected to brutality that resulted in the death of reasonably caused her extreme pain. Carol, the fact that these two separate aggravated physical abuse, I believe that was properly scored.
Thank you, Tom.
Judge, the next objection that I had related to the scoring of offense variable 8, that relates to victim asportation or captivity. The specific definition that's contained in the guidelines as it relates to that indicates that victim, to score 15 points, the victim has to be escorted to another place of greater danger or to a situation of greater danger or was held captive beyond the time necessary to commit the offense. I don't think we've had any evidence that was presented during the trial in this matter of any asportation to a different area. I'm not sure if this relates to an argument that at some point the kids may have been in their room, but again, they weren't taken anywhere else other than the home. I just don't think the facts as presented here fit this variable. We would ask the court to consider scoring it 0.
And again, Judge, I would echo the sentiments of Mr. Lepley. I mean, what we have here is we have a small house, we have a bedroom for the children. We know the children spend a lot of time in the bedroom, as children will do. There's absolutely no evidence here that these children were escorted to a room where they could otherwise be abused. It's simply no evidence here to support that.
And I think the defense is focusing only on the asportation element of OV8. There's also an aspect where a victim is held captive beyond the time necessary to commit the offense. I think the testimony presented at trial, you had information from Dr. DeGraw that a child will not starve if they can avoid starving. There was ample food in the home, and you had the evidence relating to the shoelace that was on the door that showed how the girls could be locked in their room. And you had the information that on the date of Mackenzie's death that the defendant, Hilery Maison, had gone to some appointments. Those children were in that room with the door shut. I think it's clear that they were systematically kept locked up so that they could not get to the food. And for that reason, preponderance does exist to support the scoring of OV8.
I think good arguments could be made in either case for this factor to be scored. Listening to the evidence that was presented at trial, I do not believe that captivity was essentially one of the ingredients of the curry here. I can't find sufficient evidence to support that scoring at 15 points. I'll sustain that objection.
Thank you,
Judge.
Thank you, Judge. Next objection we had relates to offense variable 10, and that relates to exploitation of a vulnerable victim. There's a specific definition that's contained in the guidelines, Your Honor, as it relates to the term exploit, and that's basically defined as to manipulate a victim for selfish or unethical purposes. And again, I don't think the facts, as you heard at trial, relate to any kind of manipulation here for any selfish or unethical purposes of my client. There's also a reference in the offense variable that this could be scored if an offender abused his authority status. And again, that's specifically defined as well, that to score the 10 points for that, there has to be some evidence that a victim was exploited because, out of fear or deference to an authority figure. I don't think that had any bearing in this particular fact situation.
Judge, I'd simply echo the sentiments of Mr. Lepley with regard to that objection.
Again, I think by its very definition, this case involved the abuse of parental authority, the abuse based upon youth or agedness, the domestic relationship. There's multiple aspects which support the scoring of offense variable 10. Certainly, this never would have happened had the exploitation of those aspects of the relationship not happened. So we would ask court to maintain the scoring as the Department of Corrections has included it.
I think the record is more than ample to support scoring 10 points. This was a situation where authority figures said it's parents and step parents, and it was the opportunity to take advantage of someone who's very, very young. So they had fend for themselves, therefore they are appropriately classified as vulnerable. Objections over.
Judge, next I would ask the court to review the scoring as it relates to offense variable 12. My client scored 25 points under offense variable 12 for 3 contemporaneous felonious criminal acts. by definition, those have to occur within 24 hours and not relate in a separate conviction. Clients were charged with 5 crimes here, Judge. They were convicted as charged. I'm not sure what the reasoning is behind scoring this variable. We would ask the court to score it at 0.
Judge, again, I would agree with Mr. Lefley. I would expect that there might be some stipulation that that's exactly the case here.
Your Honor, actually, my concern is not so much with offense variable 12, but I think that those points should be scored on offense variable 13. It is accurate, offense variable 12 cannot be scored where it results in a separate conviction. However, offense variable 13 would provide for 25 points if the offense was part of a pattern of felonious criminal activity involving 3 or more crimes against a person. Again, certainly you have that. You have 3 convictions in this case. So where the court may uphold the objection to the scoring of OV 12, I would ask that the court score OV 13 alternatively at 25 points.
Response?
Judge, I don't think there's any evidence to support scoring of OV 13 in this case. I mean, certainly I understand that the prosecution's theory was that this occurred over a period of time, but there simply wasn't sufficient evidence in the record to support OV 13 scoring of any points at all in this case.
Judge, I would agree with Mr. Boucher in this matter.
I'm going to agree with Ms. Armstrong. I believe that 12 parameters are best variable. 12 may not be appropriate in this approach to score these points. Under offense variable 13, it's part of the continuing pattern of criminal behavior. This clearly shows that this was not an isolated incident that occurred, a momentary situation over a period of time. If the abuse was continuous, I believe that the proper score
25, Your Honor.
25 points. That's the appropriate for 13.
Judge, the final objection we had as it relates to the sentencing guidelines relates to the scoring of 10 points on OV 19. As the court is aware, that relates to the interference with the administration of justice. Mr. Mason scored 10 points on that variable. Again, this wasn't a situation where there was physical resistance or resisting and obstructing type thing. He gave a statement to the police. I'm not sure that that's appropriate based on these facts and circumstances. I don't think that his actions indicate that he interfered with the administration of justice here.
Judge, we just received the guideline scoring sheet this morning. Frankly, I can't imagine why OV 19 would be scored in this case, based on my understanding of the facts.
Response?
Your Honor, my anticipation is that the Department of Corrections may have scored OV 19 based upon the the statements made by both defendants, by Hilery Maison in the 911 call and 2 emergency responders and police personnel when they arrived. As I believe it was Lieutenant West testified, it was necessary for them to get information so that they could appropriately and be able to treat Mackenzie Maison, and particularly when she was rushed to the emergency room, and they were given false information at that time. So I would anticipate that's why that variable is being scored.
I can understand the theory. I just do not believe that it's supported actual evidence. The objection will be consistent.
Thank you, Judge.
Thank you, Your Honor.
Your Honor, there's one more on OV 17. I'm not sure that those would apply to these types of offenses. That's a degree of negligence in the operation of a vehicle. So I have to look for the Department of Corrections on that.
That would be correct.
Judge, I mean, very clearly that wouldn't apply.
Yes, for it to be correct.
Judge, I have no additional objections to the guidelines. It's my understanding, based on the judge's or the court's ruling, that the total OV points would be reduced, I believe, to 205. Would not change the guidelines at all.
And I would agree with that, Judge, and I have no challenges to the scoring of the prior record variables.
Likewise?
I agree, Judge.
Okay. Additional comments?
Judge, really don't have much to say on behalf of Mr. Mason. Obviously, this is a tragedy for everyone involved, for the children that were involved, for the extended families, and for the parties as well. But discuss this matter with my client. He understands that the court really doesn't have any discretion in terms of sentencing as it relates to the felony murder charge. As it relates to the other counts that were not mandatory life, but life or any term of years, we would only ask the court to consider granting a term of years.
Judge, likewise, we understand my client, I've explained to my client that the court has no discretion with regard to the felony murder charge. Like Mr. Levely suggests, some term of years with regard to child abuse and torture charges would be what we would be requesting here.
Would the defendants themselves like to speak?
Judge, I've discussed with my clients, my understanding that Mr. Mason will not be making a statement.
Likewise, Mr. Mason will refrain from making any comments.
Anything to be stated by the prosecutor or any victim would like to address the court?
Yes, Your Honor, and I know the court is in a unique position, having heard the testimony and evidence in this case. I think it's evident the gravity of the behavior that brought this case before the court, ultimately causing Mackenzie's death and severe harm to Michaela. This case, for all of us involved, from the prosecutor's office, the law enforcement involved, I know from the Port Huron Police Department, was very difficult for the reason that it's incomprehensible how these defendants could have chosen to engage in this prolonged, purposeful malnourishment, starvation, maltreatment of these children to the extent that it ultimately caused this harm. This was not something, and I know this court knows, it did not happen overnight. It didn't happen in a period of a few weeks. This took months to get to the point that these children were in the grave state that they were in. And it's just by virtue of Mackenzie having gotten pneumonia first that she passed. And Michaela certainly was in a position on that day when police responded that she was likely going to die as a result of the condition that the defendants had put her in. And it's unfathomable how parents could not only allow that to happen, but to purposefully cause that to happen. That is a specific, special kind of evil, Your Honor. And that's something that I know, even if the statute didn't call for a natural life without the possibility of parole sentence, that is the right sentence for these offenses and for these defendants. So that is the sentence that I'm asking the court to impose on count 1. As it relates to the remaining counts, the recommendation is life. That is a somewhat complicated area under Michigan's statute, life for law. I'm asking the court to actually impose a term of years for the offenses of child abuse and torture. Guidelines, you don't have to follow guidelines given the first-degree murder offense, obviously, but guidelines, I think, do provide an appropriate range, topping out at 225 months. So I'm asking the court to impose that sentence for the offenses counts 2 through 5. And Your Honor, I would also note that Mackenzie and Michaela's mother is present and has asked for the opportunity to address the court.
Shelby Coffey, C-O-F-F-E-E. I am Mackenzie and Michaela's biological mother. And bear with me, my emotions are a little bit high right now. So I'm just going to read my paper.
Relax.
My girls never had the chance at the hands of these defendants. The defendants were supposed to raise them and give them a childhood. That childhood was taken from my girls, from Mackenzie and from Michaela. Michaela almost didn't get that chance. The defendants took it upon themselves to take care of 2 children in the home, but not 2 of the others. I am angry. Why just my children, I ask myself. I want the defendants to learn from their mistakes, from their choices. I want them to see what they did was wrong. Everyone has good in them, but evil had to have taken over. Mackenzie just missed her 6th birthday, March 3rd. She will miss out on going to school. She doesn't get to have an imagination. Imagine what she will be when she grows up. Her imagination was taken from her. at the hands of these defendants. She doesn't get to be silly. She doesn't get to be a big sister, a role model to Michaela and my youngest, Melody. She doesn't get someone to love her and care for her like she should have every day. Michaela doesn't get to have that big sister to look up to. She has to take that role on herself as the big sister now. She will miss out on talking to her sisters about her frustrations when she gets mad at me, or even talking to her when she hits her teenage years about boys. She will miss the advice that her big sister would have been able to give her. She has to live every day knowing her sister wasn't sick just from pneumonia, but she has to live with the facts that that person she was supposed to count on and have that trust in took her sister's life away. She is labeled with this for the rest of her life. Her past will always haunt her. Even though Mackenzie was a strong soldier, she didn't make it. But Mackenzie is always Michaela's angel. She'll always be the spiritual role model, not only for her little sisters, but for me, my family, and this community. I want the community to stand up and say something if they see something wrong. Let this case be a lesson to everybody. If there's something you say, if you see something, say something before any more children's lives are lost.
Appreciate what you're doing. You have a perspective that not everyone has it. When you're sitting on the bench, you look at the audience and you see their reaction to the evidence, and I'll never forget violently you reacted to seeing a picture of Michaela when it was put on the screen, and how you had to run out of the courtroom, and I saw you collapse in the fourth hallway. I just can't imagine the pain that you went through. I'm so sorry for you.
Thank you.
Does anyone else would like to address the court? One would like to believe that tragedies such as this rarely occur. Unfortunately, this has not been my experience. Mackenzie Maison joins the names of two other child victims whose cases I presided over, Grace Galvin and Diana Swinson. All three murdered by parents and step-parents. This monstrous act defy explanation or understanding. What puzzles me is how in a community so dedicated to combating child abuse and neglect, these conditions go undetected until it is too late. Obviously, those directly at fault, children from the outside world. They're too young for school and are not brought to a doctor's attention. However, family and friends have to know what is going on. Too many people, good people, choose not to get involved and turn a blind eye to reality. It is said that all that is necessary for evil to triumph is for good people to do nothing. What happened to Mackenzie and to her sister Michaela is evil. Those who saw and chose to do nothing are, in my mind, equally responsible for this crime. They must share the blame. Hilery Maison. In count one, charged as a felony murder, is the judgment of this court. You be committed to the Michigan Department of Corrections, serve a term of life without parole. Credit given for 288 days served. You must comply with the DNA testing requirements and pay a $60 fee. Pay a state minimum cost of $340 each, and a victim's assessment fee of $130. Court costs are set at $300 if you're able to pay at any point in the future for attorney fees who are to reimburse those costs. On the remaining charges, counts 2 and 3 of torture and 4 and 5 of child abuse. This is the court's determination that it will follow the recommendation of the Michigan Department of Corrections and impose a period of life imprisonment with credit for 288 days. Certain instances of offenses which run concurrent with one another. Now, you are entitled, of course, as a matter of right, to have these convictions and sentence reviewed by the Court of Appeals, asking that the attorneys approach this time to receive the appellate rights forms and the application for appellate counsel. you complete those forms, we will see to it that a qualified attorney is appointed for you. They get filed and complaint with the field. It's indicated since you've been convicted by the trial, jury, you have troubles in that break, you have the court of appeals review the cases. So if you need any assistance in completing